Welcome back to Chapter 13, the Appellate Process and Judicial Process. In this chapter, we'll discuss the nature of the appellate process, the business of appellate courts, caseloads and expedited processing techniques, and post-conviction remedies. In addition, we'll discuss decision-making on appellate courts, explain decision-making on appellate courts today. We'll discuss state Supreme Courts and the United States Courts of Appeals. Appellate courts are subject to the decision of another court to a second look. They focus on the legal controversy rather than the facts in a case. It contributes to the legitimacy of the legal system in America, and only a small number of cases decided every year in trial courts will be appealed. Appeal courts are multi-member. Intermediate courts of appeals typically hear cases as three-member panels. Appellate cases present controversies about the law, and the decisions are binding on all courts within that Court of Appeals jurisdiction. The purpose of an appeal is error correction. That is, to ensure the law was correctly applied during trial. It's also policy formulation, sometimes referred to as lawmaking. It happens when the court fills in gaps in the law, clarifies doctrines, clarifies the law, and overturns previous decisions. The scope of appellate review is when the losing party at trial generally has the right to one appeal. Only the losing party may file an appeal. Prosecutors may not appeal not guilty verdicts. The Constitution protects citizens from double jeopardy. Being prosecuted twice for the same crime is double jeopardy. Therefore, prosecutors may not appeal not guilty verdicts. Appeals are discretionary, except for capital punishment cases. Most losing litigants will not file an appeal. Appeals must be from final judgments, focus on questions of law, not fact, and issues appealed must have been raised during the trial, such as objections during a trial. The losing party only has a right to one appeal. Appeal courts have mandatory jurisdiction over some matters and discretionary jurisdiction over other matters. The appellate court procedures generally follow 6 steps. Launching the appeal, where the appellant, the losing party in the lower court, must file a notice of appeal. Preparing and transmitting the record, where the papers and exhibits are transferred from the lower court to the appellate court. Writing and filing briefs. A brief is the written argument stating why one side should win. There's the oral argument, where lawyers for both parties are given an opportunity to argue their case before the judges. There's the writing of the opinion. After the case has been decided, the judges will decide the case, writing an opinion which summarizes the facts as explained and the legal issues at issue. Judges who disagree may write dissenting opinions, explaining why they disagree with the majority opinion. There's the disposition of the case. The appellate court may affirm or uphold the lower court decision, may modify, change in part, or reverse, set aside the lower court. Sometimes the court will remand the case or send it back to the lower court with instructions on how to act. So appellate courts modify, reverse, remand, or reverse and remand cases only when there is error at the trial level. Substantial error is reversible. Trivial errors are deemed harmless. This table shows the steps of the criminal procedure appellate process. This is for criminal procedure appellate process. The business of appellate courts mean that they have limited original jurisdiction. That is, appellate courts are not the first level of court access for any dispute. They have limited original jurisdiction. Most cases come to them on appeal or a review of a lower court decision. Most trial court filings are never appealed because the parties reach mutually agreeable voluntary settlement. In civil appeals, there are 3 facts that drive the decision to file an appeal. 1, how much litigants have lost in the lower court. 2, likelihood of success of the appeal. And 3, financial considerations of the appeal. A substantial number of appeals are filed every year. In federal courts, civil appeals are more likely to be reversed, 12%, than in criminal courts. Research has been conducted that shows resources may matter the most at the appellate stage. Indigent defendants have a right to appeal because of the Warren Court decision in the 1960s. Today, criminal appeals constitute about 50% of all appeals. Criminal appeals tend to be relatively homogeneous, largely routine, rarely successful, and those who are successful are likely to be the least serious offenses. After World War II, the appellate caseload grew dramatically. There has also been a shift in the type of cases. Today, they are much more complex than those of previous decades. The response has been to increase resources, more courts and more judges, and to improve efficiency. The first response was to create intermediate courts of appeals and additional judgeships, creating additional staff for judges like law clerks who can do some of the routine work, but there's no guarantee that increasing resources will result in less delay. Improving efficiency assumes that all cases are not the same. Some can be handled very quickly, while others require a time-consuming review. Some argue for eliminating oral arguments altogether, because oral arguments tend not to persuade the judges who have already reviewed the briefs. Issue summary affirmations, such as affirming the lower court ruling with offering an opinion, also seem to improve efficiency. Generating unpublished opinions has the benefit of reducing workload and concern over the amount of law one must study to become a lawyer. Another reform effort focuses on settlement conferences, which focus on creating policy. Settlement conferences help the parties reach mutually agreeable positions. What are some post-conviction remedies? Well, after the appeals process is over, federal prisoners may challenge their convictions by filing a lawsuit. These differ from appeals because they can only be filed by prisoners. They're limited to constitutional defects. They are not limited by issues raised at trial, and they are unlimited in the number that can be pursued. Post-conviction remedies are referred to as habeas corpus, an order to someone holding a person to bring that person before the court. Protected by Article 1 of the United States Constitution, habeas corpus is often described as the Great Writ. It prevents governments from jailing citizens without filing charges. Expanding and contracting the Great Writ was originally seen as an extraordinary effort. Yet in the 1960s, the Warren Court expanded the scope of habeas corpus. Recent courts have cut back on habeas corpus relief. The Warren Court in the 1960s expanded the scope of habeas corpus, and so we saw from 1960 to 1996 an incredible increase of habeas corpus petitions. Recent courts, however, have cut back on habeas relief. Petitioners are rarely successful, only perhaps 2% of the time habeas corpus relief is granted, and 98% of the time it's denied. The 1996 Anti-Terrorism and Effective Death Penalty Act does impose a one-year deadline for filing habeas petition. It limits successive positions. It restricts review of state petitioner claims, and it requires a certificate of appealability. It limits on habeas challenges, but Supreme Court has upheld the law. Lengthy review process is seen by some as being soft on crime. Decision of courts may be reviewable by another level of courts. Decisions are made by groups of judges, and so political scientists have focused a great deal of energy on trying to explain the appellate court decision-making process. A large number of appellate decisions are non-unanimous. Non-unanimous decisions are interesting to study because there is disagreement about the law across judges who are looking at the exact same case. Disagreement happens on all courts: the Supreme Court, courts of appeals, and state Supreme Courts. Political scientists offer 4 ways to explain such decision-making process. First, legal factors. The legal model asserts that judges make decisions primarily based on the facts of the case, the legal statutes involved in the controlling legal precedent, such as stare decisis. Advocates argue that law cannot be the only factor because otherwise all judges would reach the same decision. The law is often contradictory. There are attitudinal dimensions. Advocates of this theory argue that judges are similar to other policymakers. Votes are one way to express their views about politics and society. So advocates focus on judges' ideologies and their values to explain decisions. There is institutional differences. Advocates of this theory argue that the format of multi-member judicial panels affects decision-making. Small groups make decisions differently than individuals. An individual judge may moderate their views to reach agreement with others on the panel through negotiations and through compromise. And lastly, the strategic difference. This approach assumes that judges act on their attitudes in a sophisticated manner. Their goal is to get the most preferred outcome in any particular case, but also to try and influence the law in later cases. A strategic judge may give up their position in a less preferred legal matter to get support on a later, more important matter. Let's talk now about state Supreme Courts. State Supreme Courts decide 25,000 cases a year. Most decisions will be the final word, since very few are reviewed by the Supreme Court of the United States. State Supreme Courts engage primarily in error correction, but increasingly they are involved in policy formation. There's an increasing focus on these courts, increasing focus in the public on these courts' decisions. Decisions by state Supreme Courts are based on state constitutional law as opposed to federal constitutional law. State constitutions are typically longer and more robust than the United States Constitution. New judicial federalism refers to the movement in state courts to use state constitutions as sources of individual rights rather than looking to the United States Constitution. There are, of course, attitudinal dimensions of voting on state Supreme Courts. There is frequently disagreements among the judges on these courts. Factors to explain this disagreement include partisan attitudes, religion, gender, age, race, and prejudicial career. Some cases leave little room for judges' policy preferences to have an impact. There are, of course, institutional differences. The legal and political context of state Supreme Courts varies considerably. Rules and operating procedures are different across states. Important differences state to state include judicial voting order, opinion assignment, control over dockets such as discretionary versus mandatory jurisdiction. And there are, of course, strategic considerations. These models include legal, attitudinal, and institutional factors. And such institutional factors include such forces as whether the judge have prior representative service, whether they are from single-member districts, and whether the case is heard near the beginning or end of a term. Models show that there is a complex decision-making process at the state Supreme Court level. U.S. courts of appeals have a new focus or political scientists have a new focus on U.S. courts of appeals. Decisions set the contours of law and policy. Most of their decisions will not be reviewed by the Supreme Court. They determine precedent in their respective circuits, and so U.S. courts of appeals have great influence and power. Legal factors in courts of appeals are significant. Courts of appeals decide over 60,000 cases per year, and most cases generate unanimous decisions. Studies have shown that precedent, that is, stare decisis of the law, is important in case outcome. Judges are obligated to apply the precedent established by the United States Supreme Court. There are, of course, attitudinal dimensions of voting at the U.S. Courts of Appeals. Sheldon Goldman in 1966 concluded that Republican judges tend to be more conservative and Democratic judges more liberal, which is not surprising at all. Research shows that Democratic presidents appoint different types of judges than Republican presidents. Again, not surprising. Judges appointed by Democrats render a greater percentage of liberal decisions than those appointed by Republicans, again, keeping in line with the political and attitudinal dimensions of voting. There are institutional differences. The 13 circuit courts of appeals are separated geographically. Research has shown different ideological and policy environments across the circuits result in different outcomes. The composition of the three-judge panel is constantly changing. The relationship of those panels to the views of the full circuit varies, three-person panels versus en banc or full circuit review. There are strategic considerations. New research has shown the Court of Appeals applies legal, attitudinal, and institutional models to explain decision-making. Studies have looked at, when en banc review is granted, whether panel judges write separately, whether there's a home state influence. Research has also concluded that all factors influence circuit court judicial behavior across the whole spectrum, whether they are legal, attitudinal, institutional, or strategic. In conclusion, appellate courts review the decisions of lower courts. Appellate court caseloads have been increasing rapidly over the years. Primarily, appellate courts are engaged in error correction, but also involve policy making. Decision-making on these courts of appeals is complex, and they combine legal, attitudinal, institutional, and strategic factors.